In Qwinstar Corporation versus Anthony, we'll see whether courts can consider evidence outside of a written contract if the contracting parties intended for the written agreement to be a complete and final expression of their agreement. Qwinstar Corporation and Pro Logistics were two companies that repaired and sold old IBM check processing systems. Qwinstar agreed to purchase Pro Logistics along with all of Pro Logistics' equipment and parts. In January of 2013, Curtis Anthony, the owner of Pro Logistics, prepared a written inventory of Pro Logistics' equipment and parts. However, Anthony continued to sell equipment and parts after he completed the inventory. Qwinstar never verified the contents of the inventory against the actual equipment that Pro Logistics had in its warehouse. Later, Qwinstar and Pro Logistics signed a purchase agreement in which Pro Logistics agreed to sell all its assets as of the date of the agreement. The purchase agreement didn't reference or incorporate the January 2013 inventory. The purchase agreement also included a merger clause that held that the purchase agreement constituted the entire agreement between the parties. At the time Qwinstar and Pro Logistics signed the purchase agreement, Anthony signed an employment contract with Qwinstar for 5 years. After 1 year, Qwinstar found discrepancies between the 2013 inventory and the actual equipment in Pro Logistics' warehouse. After discovering the discrepancies in Pro Logistics' inventory, Qwinstar fired Anthony and sued him for breach of the purchase agreement. Anthony counterclaimed that Qwinstar breached his employment contract when Qwinstar fired Anthony. Both parties sought summary judgment. The district court held that Qwinstar couldn't establish its breach of contract claim because Qwinstar was aware that Anthony was still selling equipment after he created the 2013 inventory. The district court granted summary judgment in favor of Anthony. Qwinstar appealed.